One of the most important issues in the Confederation period was the problem that Americans faced with debt, not only public debt, but also private debt. Virtually everybody in the United States was in debt. Even the wealthiest people had some kind of a debt. And the danger existed when one person, particularly a fairly wealthy person, let's say, would go bankrupt. That would set off a chain reaction, and others would suffer and might well go bankrupt. If you couldn't pay your debts and couldn't pay your taxes, you were often thrown into debtor's prison, and your family had to support you there, and you stayed in debtor's prison until your creditor said that it was all right that you be released. There were almost no bankruptcy laws at the time in colonial and revolutionary America. There were insolvency laws, and the difference between the two is that an insolvency law protects the rights of creditors and their interest, whereas a bankruptcy law protects the rights of the debtor. And so it was the creditors' interests that were smiled upon here by most legislatures. Every once in a while, however, the legislatures were dominated by people sympathetic to the plight of debtors, and they would pass relief measures of one kind or another. Sometimes these were tender laws, sometimes they were stay laws, and that allowed creditors a bit of leeway. A tender law would be that you could substitute something other than gold and silver in payment for a debt that you owed. That could be corn, it could be tobacco, as it was in Virginia and Maryland. It could be sort of worthless land in the West, as was the case in South Carolina. They passed the Pine Barren Acts, and any British creditor who wanted to collect a debt would be offered this worthless land on the frontier. The creditor didn't want the land, and in fact, if you had the land, you had to pay taxes on it. And so, to a great extent, these tender laws often were used as stay laws. That is, they delayed creditors in having their debtors arrested and thrown in debtor's prison. Sometimes paper money would be made a tender, let's say, but only in cases of suit. And so paper money would not be a tender if you just went and bought something. The creditor or the merchant wouldn't have to accept the paper money. But if they sued you, took you to court, then they would have to take whatever the tender was, if it was paper money, or if it was corn, or if it was some farm animal. Generally speaking, when a tender was offered, whatever that tender was, it meant that the creditor had to receive that tender. If they didn't receive it, from that point on, interest would stop on the debt that you owed. You still owed the debt, but you no longer had to pay any interest. Now in Rhode Island, they took this a step further, and they provided that if the creditor did not accept legal tender paper money, and the legal tender paper money depreciated almost to nothing, but if the creditor refused to accept it, the debtor could then lodge his paper money with a local judge. The judge was advertised in the newspaper, Know Ye, and Rhode Island became known as the Know Ye state. Know ye that John Smith has lodged with me, let's say £100 in payment of a debt to John Brown. And if John Brown didn't collect the debt from the judge within a certain period of time, 2 or 3 weeks, the debt was forever canceled, and the state of Rhode Island would keep the lodgement money minus whatever fees there were for the judge and fees for the newspaper advertisement. And so Know Ye became a symbol of the attempt to relieve debtors of payment of their debts. And there was an argument that this was a fraudulent activity, and Rhode Island was widely condemned for the multiplicity of Know Ye's advertisements in the newspapers.